I have previously written on what happens when a person dies insolvent, i.e. their debts are greater than the value of their assets. I am now switching a bit. Over the next few weeks, I am going to be writing a series of blogs and vlogs to explain why I believe that a licensed insolvency trustee, formerly called a bankruptcy trustee, is the professional you should be thinking of making the executor of a deceased estate and recording it in your will. I will show how, based on the knowledge and expertise possessed by licensed insolvency trustees, it makes them the perfect candidate to serve as an executor of a deceased estate that is rich with assets. I caution that I and my firm are not lawyers, and I am by no means providing in this and upcoming Brandon TMS blogs advice on wills or estate planning matters. For that, you must consult your lawyer. In this blog, I wish to set the stage by going over some basics when it comes to a deceased estate. In Ontario, an estate trustee, also known as the executor or executrix, is the only individual with the lawful authority to handle or disperse an estate. When an individual dies, they might leave items, property, real estate, cash and investments and other possessions which is called their estate. Probate is a treatment to ask the court to provide an individual with the authority to work as the estate trustee of an estate. Verify the authority of an individual acting as the estate trustee named in the deceased's will, and officially accept that the deceased's will is their legitimate last will. You can apply for probate in the Ontario Superior Court of Justice. If your probate application succeeds, the court will provide a certificate of appointment of estate trustee, which is evidence that an individual has the lawful authority to manage the estate. A probate certificate is not needed in every situation for a deceased estate. An application for a probate certificate is normally made if the departed individual passed away without a will. The deceased's will does not show an estate trustee. A financial institution desires evidence of an individual's lawful authority to get the cash or financial investments of the deceased. The estate's properties consist of real estate which does not pass to an individual by right of survivorship. There is a disagreement about who ought to be the estate trustee. There is a conflict or possible conflict about the legitimacy of the will, or some of the beneficiaries are unable to supply legal consent. What should the estate trustee TMS first steps be? Here is where the actions the estate trustee should immediately take are almost the same as those taken by a licensed insolvency trustee. Obtain the will and financial records. Have proof of authority. Take possession and control of the assets, make an inventory and establish market values. Insurance and bonding. In general terms, an estate trustee acting on behalf of beneficiaries, just like a licensed insolvency trustee acting on behalf of stakeholders, has the following responsibilities. Be impartial amongst beneficiaries. Act in a commercially reasonable way. To act in the best interests of the beneficiaries. Not make decisions for individual gain. Keep accurate records of all decisions made and actions and activities, and acting in accordance with the will if one exists. If you have any questions about a deceased estate and the need for an estate trustee, whether it is solvent or insolvent, contact the Ira Smith team. In my next blog, I am going to write about a topic that is becoming more and more common in deceased estates, picking the right estate trustee.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.